is a wrong assumption. I've never run for political office in the bar. It's totally different from I've never been interested in politics of the bar. Right from as far back, I'm trying to remember which one is the first annual general conference, electoral annual general conference that I've attended. I think it was the one that brought in Chief Olani Kwekun, or maybe even earlier. But I've always been interested. I've always been interested in the politics of the bar. And I think people conflate interest with running for office. I don't agree that the two are the same. Because I've realized that my passion for the profession and my concerns about the direction in which the profession is going cannot be addressed by just criticizing on the sidelines or by holding business luncheons and talking about problems and talking about solutions. Those solutions are not going to self-execute. So after several years, at least this is the 13th year now, where I can actively refer to specific things that I've been doing, expressing my concern about the way our profession is going. I think after 13 years of talking, I took the hint, which had been implied and also expressed by some, that, you know what, if you really want things to change, you need to do a bit more than just talk about those changes. You need to try and implement them. It's a wrong assumption. Those who know me, my friends who are close to me, and I can mention at least 3 people that you can ask. Mr. Yodede Lalo, Dr. Wale Olawoye, Mr. Kayode Eniton will tell you that at various times in the past, I'd mentioned to them that I would like to run for president of the NBA. So it's not a latter day. The 3 areas that I'm particularly passionate about. One is the welfare of the legal professional. I think our profession has lost a lot of the respect and dignity that it used to command because the welfare of the legal professional has been so downgraded. So that's one. I mean, I can elaborate on it if there's time. Second is justice sector reform. I think whatever type of law one practices, even though those who are corporate practitioners seem to think that the courts have nothing to do with them. But my view is the courts have something to do with everybody. Even if you're a commercial practitioner and you're negotiating agreements lead to disputes have to be resolved. If you live in an environment where the resolution of disputes is as inefficient and dysfunctional as we have in Nigeria at the moment, it cannot but have a knock-on effect on the quantity of commercial transactions that you will have in that space. So I think fixing our justice sector is a second area that I would want to concentrate on. Third, which I think is a related point, is self-regulation and discipline. Because I think a lot of the problems we have, even in terms of our welfare, in terms of the dysfunctionality of our justice sector, has to do with the fact that we're not regulating or disciplining ourselves properly. And by ourselves, I'm not talking just about lawyers. I'm talking about both lawyers and judges. The big elephant in the room, it's a hydra-headed problem. And I think that we need to start from the basics. Right now, I think it is difficult to dimension just how bad the welfare situation is because we don't even have the necessary statistics, in my view. You know, when you talk about welfare to a lot of lawyers, especially the younger lawyers, they're thinking just in terms of their remuneration. their take-home pay or the salaries are inadequate. But I think the challenges of welfare in the profession go way beyond that. That is part of it, but it's just a part of it. I think the welfare of the profession goes to even the income generating capacity of the legal profession. Given the fact that we're producing 7,000 or roughly 7,000 lawyers every year, is the profession itself generating a sufficient income to carry that base load? I don't think it is. And that's what I think we need to look at, which will obviously then cascade into better remuneration for those who practice the profession. So one of the primary things I would like to do at the earliest possible opportunity, if I'm elected president, is to engage with the Attorney General of the Federation. In our Legal Practitioners Act, there's provision for a Legal Practitioners Remuneration Committee. It is that committee that in 1991, when Prince Bola Ajibola was Attorney General, that established the Legal Practitioners Remuneration for Land Matters Order of 1991. Nothing else has been done since then. So first, I think that committee is established by law because it is expected that we would put scales of fees in place for as wide a variety of legal work as possible. And this is just a minimum scale in my view. You can always charge more, but at least let's have a base that ensures that we're not all engaged in this race to the bottom. Because one of the things that's killing our profession now, probably because there's so many of us, is that every time you tell a client this is your fee, the client will tell you, oh, I know somebody who would do it for half of that. And then we'll go to that one and there's somebody who would do it for half, until we all end up doing more for less. And then we wonder why the profession is becoming so talking about profitable is not even the issue. It's becoming impossible to sustain its practitioners. So I think we need to attack that. I think we need to get that committee reconstituted. We need to put scales of fees in place. Then we need to attack the real problem, which is that even the existing scale of fees we've not succeeded in enforcing it. We need to put these scales of fees in place and we need to enforce them. I had a conversation with a gentleman just this morning who is a lawyer. He's also a chartered surveyor. And I was saying to him that in their space, there are other professions where they seem to have done better than lawyers in managing to enforce scales of fees for services they render. And he said even with them, it's not perfect, but that at least they're doing a much better job than we are. That when they're dealing with private sector clients, there's still the tendency for some degree of undercutting. But that when they're dealing with, public institutions, everybody insists on the scale because the scale is actually put in place by their regulators. I think we can take a leaf from that. And he also made the point, he said it's just a matter of discipline. And this is why I say all these issues are connected, because if our disciplinary system is working properly, if we know that these rules have been put in place for our own benefit, to sustain our livelihoods, then I think it's the height of indiscipline for anybody to go against it. If organizers can agree that this is how much we're going to fix a tire, and anywhere you go in Nigeria, you won't get your tire fixed for less. I think we as lawyers we should take it as a challenge, that we should also put scales of fees in place and work out a mechanism for enforcing those scales. It will be for everybody's benefit, not just for some. So whether you're a young lawyer, you're a middle-aged lawyer, you're an old lawyer, it will benefit all of us. It will improve our welfare tremendously. So that for me is the flagship of my welfare proposals. There are a lot of others. I mean, of course, aside from income, aside from remuneration, I think there are a lot of other things that affect the welfare of the individual. Conditions of service in the workplace, sexual harassment in the workplace, adequacy of training, opportunities for career development, mentoring, and a wide variety of issues that I would like to deal with. But like I said, that for me is the flagship. I think if that's, at least as far as welfare is concerned, if that's the only thing I can achieve, because an MBA presidency is just 2 years. If I can in 2 years put the scale of fees in place and put a system in place that ensures that it is being enforced, I think I would have done well. And then somebody else can take off from there. Definitely. For me, the problems of the justice sector relate to 3 key issues. Resources. I think the justice sector is severely underfunded. Management. I think that our judicial officers don't have the skills that are required to manage the justice sector properly. And I'll elaborate on that in a bit. And then third, I think that we need to address the entry point into our justice sector. Because as I say to people, a lazy, corrupt, and not particularly smart lawyer is not suddenly going to transmute and become a smart, hardworking, intelligent judge. Just that kind of magic doesn't happen. So, if we look at the history of our justice sector and of our judiciary, I mean, Nigerian judges used to be export products. People would go from our Court of Appeal and go and be made chief justices somewhere because they were so good. And when you look at who those people were, the Justice Ayolas of this world, Justice Kayode Esho, I mean, the great names, these people were the best of the bar that went to the bench. Over the years, somehow that trend has reversed. So it's not the best of the bar that is going to the bench, and we're seeing the result in the level of dysfunctionality in our justice sector. So those are the three aspects of justice sector reform that I would like to focus on. One is judges are not in a position to agitate for more resources, or maybe not to agitate as effectively as the bar can. And I think that if we look at our profession as a united profession, where both judges and lawyers and members of the profession, we at the bar should take up that mantle to agitate. Recently the president passed an executive, or passed, or I don't know whether it's passed or promulgated, whatever the proper language is, Executive Order number 10, trying to enforce the provisions of the Constitution that say that the state legislatures and state judiciary should be given financial autonomy. Great idea. The concept, the intent behind that is good. I mean, question whether the federal government itself has done sufficiently well in terms of financial autonomy for the federal judiciary. But over and above financial autonomy, I think there's a challenge with the budgeting for the judiciary. Because financial autonomy, in the way in which it's being described, is that whatever has been budgeted to you, you have freedom as to how to disburse it. But how was that budget arrived at in the first place? So if the financial autonomy is over something that is grossly inadequate, it doesn't really solve the problem. I mean, we're dealing now with the aftermath of COVID. We're talking about virtual hearings. We're talking about e-filing. If the judiciary is not properly funded, all that is just talk. It's not going to happen. And the truth is, as a percentage of the country's budget, the budget for the judiciary has reduced year on year over the last maybe 15 years. So it's almost as though the government doesn't realize the importance of the role that the judiciary needs to play in a civilized society. So I think that we need to address that. And I think that our judges need to allow themselves to be assisted, which takes me to the second point about drawing a distinction between the administration of the courts and the administration of justice. The administration of justice is clearly a matter for the judges. That is entirely the exclusive preserve. But the administration of the courts, which is where the judges operate, should not really, in my view, be the exclusive preserve of the judges. They need to bring people in who are managers, who can manage the system properly. Judges are not necessarily trained to manage. And that's why our courts are so dysfunctional. I mean, you go to court and even when the judge wants to work, of course, whether the judge wants to work itself is a major problem, which we'll deal with when I talk about discipline. 8 times you go, the court is not sitting, 8 times out of 10. But even when the court is sitting, they're looking for the file. They can't find the file. Oh, yes, I filed it. The litigant and the counsel has proof of service. Well, it's not in the file. So, take a date. I mean, it's ridiculous. That is all failure of management. And that is because the judges are not focusing on administering justice. Let somebody else manage the system. Let somebody else be in charge of staffing, making sure that the people that are there know what they're supposed to be doing, making sure that processes that have been filed have been served. All these things are back office things that should be done so that by the time the judge comes to court and sits, he's assured that he's there to do judicial work. And all these hiccups will not come into play. Even what I said about budgeting, the budgeting for the judiciary should not be done by judges. It should be done by people who have financial acumen, who can plan ahead, who can tell you that, look, over the next 5 years, given the caseload in Lagos, we're going to need 300 more judges. And for 300 more judges, this is the amount of money you're going to need. So we can start budgeting, have a rolling plan. Just like you have a rolling plan for the country, you should have a rolling plan for our justice sector. But we're doing it hand to mouth, day by day. And the judges are, with the greatest respect to them, not capable of dealing with what I envision for a proper functioning justice sector. So I would like to also start that process of changing, drawing a proper distinction between the administration of the courts and the administration of justice. Even if I don't see it through in a 2-year period, if we can start that revolution, I think it will stand us in good stead. And then the third, like I said, is the entry point. I think we need to pay a lot more attention to the quality of our judicial appointments. There's nothing we can do about those who are in there already. And of course, I'm generalizing. We have quite a number of brilliant judges even now. But I think it would be dishonest to say that we're happy with the quality of all our judges. And these things all affect each other. So I think that the criteria for judicial appointments must be strengthened, and it must be enforced strictly. We're all aware of, or should be aware of, the current scandal in the FCT, where 70 judges were recommended to Mr. President for appointment. And there's an allegation that more than, or just under half of them actually don't even meet the basic criteria that are in existence at the moment for judicial appointments to a superior court. I think that's a matter for great concern. I think that those conditions should be even more stringent, but even the present conditions, it appears that they're not being met. Our judges, a significant number of our judges, I believe, I understand, are appointed based on base considerations, political connections, godfather, or related to an existing judicial officer. And that can't be the criteria for appointing judicial officers. So I think that, again, the bar must play a more active role in ensuring that it acts as a proper filter and stops this from continuing. Yes, it is. And I've actually I've made a commitment to them. I made a commitment to the Law Officers Association of Nigeria that if elected president of the NBA, I would address that issue and one other issue. The issue of the two issues they've raised with me, because I've interacted with them quite extensively. The first is their desire to be registered with the CAC as an association under Part C. And I've told them that I have absolutely no problem with that. I was the pioneer secretary, then vice chairman, and then chairman of the Capital Market Solicitors Association. And that association had similar challenges with the NBA at the time. It took us maybe about 3, 4, 5 years before we could convince the NBA to withdraw its objection to our application to register with the CAC. So what I've said to Loan is that they should consider doing exactly what we did. And what we did to assuage the NBA's concerns, which was that we were going to balkanize the bar, was to say to them that, look, we recognize that the NBA is the umbrella body for all legal practitioners in Nigeria. And that what we would do is that in the CMSA, the Capital Market Solicitors Association's constitution, would make it a condition for membership of the association that you have to be a member in good standing of the NBA as a precondition to being a member of CMSA, making it clear that CMSA was not a parallel body to the NBA, but was a subset. It's just a body that's been set up to cater for the interests of members of the NBA who are engaged in capital markets work. So same way, I don't see any reason why Loan should not register. They're members of the NBA, just that they're members of the NBA who happen to have a common interest, which is that they're law officers. If they do that, I would definitely not have any objection to their registering. The issue of their appointment or their being eligible for election to national office is slightly more tricky. There's a provision in the NBA Constitution that actually affects not just them, but all lawyers who are not private practitioners. I think it's section 8.3, which says that to be eligible to run for national office, you must be a private practitioner. Now, what I've said to them is I don't think that there's justification for that blanket restriction. However, I think that there is justification for some restriction, because after all, we all must be jealous to protect the independence of the legal profession. A Nigerian Bar Association that is headed by law officers who are employees of government, I don't think will be considered to be particularly independent. And secondly, I don't have the statistics, which again is a problem, but I don't have any doubt in my mind that private practitioners constitute the majority of lawyers in Nigeria who are members of the NBA. So if you reserve certain positions to the majority, and if you reserve certain positions in order to protect the independence of the association, I don't think there's anything wrong with that. But then I don't think that that's justification for saying, only private practitioners can run for national office. So my view would be that we should look at amending the Constitution to reserve certain offices, perhaps the office of the President, the office of the General Secretary, who are the key officers of the association, and maybe the offices of the Vice President. Reserve that for private practitioners. But other offices, I don't see why law officers, corporate counsel, in-house counsel cannot run for them. Yes, it is one of the things that I would like to look at under the under the rubric of welfare. Welfare cuts across a pretty broad spectrum, and the legal profession itself cuts across a pretty broad spectrum. So the legal practitioners that would typically be affected by what you've described would likely be in a particular class or a particular type of practice, and they need protection as well. The clients that would typically engage foreign or international law firms usually will be either foreign clientele or multinationals who are operating in country. And they always have a default, they want to default to their own firms that they use back at their base, or sometimes for convenience. In my experience, it's not even so much default, it's just convenience. If you're a multinational and you've got operations in 32 countries, rather than having to instruct 32 different law firms, if there's a law firm that tells you that, oh, don't worry, I can cover you in all the 32, I can cover you in 24. So you just have one point of interface. It makes life a lot easier for them. And that is something that we need to address in terms of scale, because it's one thing to want to protect your market. It's another thing as to, do you actually have the capacity to do so? If we don't also start thinking from an international perspective and we're just looking at our local market, I think it restricts us considerably. So in a direct answer to your question, I think it is a matter for concern. I think it is something that ought to be addressed, but I think we need to be pragmatic about it. Some of what you've described is what you call fly in, fly out. And it's very difficult to stop it, because let's not fool ourselves. If a US company comes into Nigeria and wants to enter into a joint venture with a Nigerian entity and says, this is the draft joint venture agreement, and it was produced in-house. It was produced by a general counsel. Now, how do you know whether that general counsel actually had that produced by, a US law firm and has paid them in dollars in the US, even though it's potentially or arguably Nigerian work. It's for a joint venture that's going to operate in Nigeria. So it might not be particularly feasible to eliminate that completely. And with globalization, the world is shrinking. I think that whilst we must do everything we can to protect our local market for as long as possible, we need to be alive to the reality that in due course, it's going to become impossible to do so to any great degree. And what we should focus on is developing skill such that we, rather than being the ones playing defense, we're actually also playing offense. And we're also setting up shop in, Ghana, Sierra Leone, the Gambia, and then further afield, London. It's happening already. At least I know 3 Nigerian law firms that have offices in Ghana. I know Olaniwa Ajayi at some point set up office in Johannesburg. I don't think it's still running. I know Aluko Anoyebode at some point set up office in London, even though that also didn't, I'm not sure they sustained it for long. But it shows that the intent is there. What we need to do is to grow the scale. And perhaps also, just like I said, it's a problem that has various dimensions. I think one area where we must enforce it, and the concept of local content, is with our own government. Because, say what you can, say what I will about multinationals. I can excuse their conduct because, they're private and they're defaulting to what is most convenient for them. But what I find quite disheartening is when our own governments, states, federal, parastatals, MDGs, when they will now, MDAs rather, will now go out and rather instruct a foreign law firm as against a local law firm. I think that is unacceptable. And if it is because you think that there is a capacity deficit, then instruct a local law firm and ask them to engage or partner with a foreign law firm that has the capacity that you think is lacking. At least that way there will be some transfer of the necessary skills, of the necessary learning. Because one of the greatest challenges you face in that sector of our market is, oh, have you done this before? Now, how do you ever get to have done it before if you don't get the opportunity to do it the first time? And we must pull ourselves up. So I think our government actually, when we talk about local content in the legal sector, I think that must first and primarily start with our government, even if it will be difficult to enforce it with the private sector. So my answer to that is, and this same question arose in a chat I had with a class set. I can't remember which law school set a few days ago. My answer to that is, if we are satisfied with the state of our legal profession today, where it has been run by those who have done social secretary, assistant secretary, publicity secretary, this secretary and that secretary, and run up through the ranks, and who have turned NBA politics into a profession in itself. If we're satisfied with where that has taken the NBA, then please, we should not change anything. But if we're not satisfied with that, and if we would like the NBA to be a bit more purpose-driven, to be a bit better at delivering on its promise to its membership, then I think we should try and do things differently. I mean, they say the definition of madness is doing the same thing over and over again and expecting things to change. So those who say this, except they're saying that they're happy with the state of the profession today, because the state of the profession today is because of this exact mindset, where a large chunk of the profession has been excluded from the management of the profession's affairs, and where there's a cadre, who feel that, we've gone from one step to the next. It's almost like promotion. I think it's ridiculous. And that is one of the reasons why we're in the situation we're in. And even in our judiciary, with the greatest respect, it's this same kind of mindset, where we're not thinking about merit, but everything is turn by turn. So you have to come one stage to the next, irrespective of whether you're doing it well or you're doing it badly. We need to shift away from this mindset and focus on delivering on service. I mean, that's why our members' welfare, and that's why your average lawyer, 99% of lawyers will tell you that the NBA is completely irrelevant to them. It is only relevant to those people who have been going from one stage to the next, because that is what they focus on. That's not what the NBA is about. The NBA should be about looking out for the welfare of every member of the association. not just about those who have made it a career. So my answer to, I owe no apologies to those who say that, oh, I shouldn't be president because I haven't gone from assistant secretary to publicity secretary to this secretary to that secretary. I think it's a ridiculous argument. And indeed, in terms of administrative experience, I built this law firm from a sole practice in Ibadan to a partnership with 5 partners with offices in 3 cities in Nigeria. I have been secretary, vice chairman, and chairman of what I consider to be the most successful lawyers association. I told you the story of how the CMSA started. The CMSA now, not only did we overcome the objection of the MBA, the CMSA is now listed in the MBA constitution as an affiliate to the MBA. I mean, so if you say I don't have I've been on the council of the SBL for 4 years. I chaired the conference planning committee for the Lagos Law Week in 2014. I chaired the conference planning committee for the SBL conference in 2016. These were all very, very successful events. I've been on NEC. I don't really think that I don't think they're being fair to themselves. I don't think they're being fair to our profession. If they want to restrict, leadership to just a small coterie of individuals, I'm not sure that's the way to go. I'm concerned. I mean, I must say I'm concerned, but I cannot but temper that concern with the reality of the situation under which we're all operating. The truth is, for nobody anticipated COVID-19. Nobody anticipated a pandemic where, people were told to stay at home. And no matter how much you do with technology, no matter how many video conferences or Zoom meetings you have, there are certain things that still require physical movement for it to be done effectively. So, I mean, the greatest challenge now I see with the activities of the ECMBA is just that everything is running behind schedule. And I think that is obviously, to me, a function of the delays arising from COVID-19. So I sympathize with the ECMBA. I would love to believe that they're doing the best they can under the circumstances. I hope that is the case. And I hope, I truly hope that we would have an election that we would all be happy with. Because, I say that I'm concerned about the perception, the image of the legal profession. I think the last 2 election cycles and the allegations and counter-allegations and litigation and accusations, I think it does a lot of damage to our standing as a profession. And I think we must all do something. And so that's why, win or lose, I'm just hoping that we will have an election that everybody would be happy with, and the winner will be congratulated by the losers. And then we'll all come together to work, to strengthen our profession. One thing I can assure you is I have no intention of going to court to litigate about whatever the outcome of this election is. It is just not, it won't happen. And to be honest, that's all I will say on this, because I don't know, the allegations I've heard, the allegations on all the different sides, and I disagree that it's just Chivato Okafor and the current president, Professor Ojukwu too. I've had conversations with him where he's also, he was a contestant in that election, and he's also made allegations. But I don't know. I wasn't a party, I wasn't a contestant in that election. And because those matters are, I don't know if they're even sub judice, they may be, but whether they are or not, to be honest, I would rather not delve into it because I don't know. There are allegations on both sides, or on all 3 sides. And I don't want to be prejudiced or prejudice myself by saying that, I think that yes, there was something that was done wrong. All I say is that I hope and pray that the ECMBA would, irrespective of what has happened in the past, let us have an election now, 2020, that we will all be proud of, and that we would be able to hold our heads high and say that, the NBA has come of age and can now, hold elections without rancor. No, there's been no assurance. First, I've not had any engagement with Mr. Tawo SAN. But then in all the releases that the ECABA has made, it has said that it is its intention to run a free and fair election. So, I'm taking them at their word. One of the, like I said, the greatest challenge I have with the ECABA now is that everything is falling behind. My expectation was that by now, we would have had an interface. All the contestants would have had an interface with the ECMBA and have a clear understanding of how the election would run, what platform it would be run on, etc., what kind of access we would have to the back end, the front end, and all the various ends. That hasn't taken place yet. And my belief is that the only reason why it hasn't taken place is because of the challenges that I spoke about earlier, that everything is running late. As you know, the election was supposed to take place on the 24th. It's been moved to the 29th because of these reasons. I hope it won't be moved again. But those are the challenges that I understand or I'm assuming have delayed these things. I believe that those interfaces or that interface will still have to take place at some point, hopefully sooner rather than later. And I'm hoping that the ECMBA will be true to its word, that it intends to run a free and fair election. That for me is the only thing we can as a profession hope for. I will not, because of allegations that have been made in relation to previous elections, second guess those who are managing this election. I'm going to take them at their word that they intend to run a free and fair election. And I must say that I haven't seen anything overt on the side of the ECMBA that would indicate to me that they don't intend to do so. If I do, I will definitely raise it with them. I have heard these allegations. The ECMBA, I think, would act on those allegations if there are more than allegations, because allegations are easy to make. What you need is proof. So I would expect that if there is proof that a contestant is going around buying votes and inducing voters, that the ECMBA would act on it. But I don't expect that the ECMBA would act on allegations. Like I said, I've heard these allegations as well. For me, I talk about the dignity of our profession. I think that anybody who is willing to sell his or her vote doesn't deserve a good NBA, because you just sold your right to demand that your association be run properly, your right to demand that your association should address your needs. You sold it because you allowed somebody to pay for your conscience. So all I would say as far as that is concerned is that I have not engaged in it. I have no intention of engaging in it. If others have, I wish them well. Yes, I can confirm that I'm aware that Mr. Akpata was in Port Harcourt. And I'm aware that there was an incident at an event at which Mr. Akpata was in attendance, and at which a colleague in Port Harcourt who supports my aspiration was also in attendance. the information I have doesn't support the allegation that he was manhandled. The information I have is that his phone, because he attempted to record Mr. Akpata's speech or whatever it is that he said at this event, that his phone was forcibly taken from him, and that the recording he had made was deleted from the phone before the phone was returned to him. That is the information I have. But he was not manhandled. That for me is the flip side of the assistant secretary, publicity secretary, this secretary. We're focusing on complete irrelevancies, those who make these arguments. I think that leadership of our profession should be based on the character of the individual, the person's track record, and the person's plans for the profession, not on the title that the person bears. So I think those who throw up all these divisive arguments, oh no, it should be a SAN, or it should be a non-SAN. I don't agree with it. I don't think the title you carry should have anything at all to do with your aspiration or your desire or your capacity to lead the profession. And I've come out publicly to say it, and it's on record. I wasn't even aware until I read what one of my colleagues said, Ferdinand Obi, SAN, that indeed there have been more non-SAN presidents of the NBA than there have been SAN presidents. So those who say it is time for a non-SAN to lead the NBA, what time? Non-SANs have led the NBA meritoriously in the past. So it's a non-issue. You know, again, it's what in philosophy or logic we used to call a red herring. You're trying to lead us down the garden path. That is not the issue. The issue is, what are you made of? You, the individual, not the title you carry. I think everybody is an equal contender. I don't have, I wouldn't describe anybody as strong or strongest. I think we all have a good chance, and I think it's good for the bar that, you know, the bar has the opportunity to choose. You know, that's what democracy is all about. Democracy is, you know, give people options, let them size up the candidates, let them look at their programs, let them look at their antecedents, let them look at their exposure, and then decide, you know what, of all this is the person we would like to lead the bar. It's a non-issue because I have no intention of stepping down. I think Paul Usoro's administration has done well. One thing that's clear to me is that a 2-year term is not it's not a long time. And I think one thing I've learned from him, from what he's done, is that you need to be pretty focused if you're going to deliver on anything. And he has been focused, in my view. He has been focused on primarily what I think is his flagship achievement, is trying to fix the internal corporate governance of the NBA. Because before now, you know, there's been so much, again, allegations, rumors, and sometimes manifesting things you see about corruption within the NBA, and the NBA itself not being an accountable or self-accounting body. I think he has done marvelously well in terms of doing that, in terms of, you know, publishing regular accounts so that we can all see and we can query if we have any queries about, you know, what happened to our money. And, you know, just like I said when I was talking about welfare, I said, look, yes, I've got a list of maybe 10 or 12 things that I would like to address in the welfare space. But the flagship one is putting a scale of fees in place and ensuring that that scale of fees is enforced. if that's the only one I achieve, and I leave the rest for others, I know I feel that I would have done well in that space. So I think Paul has done well and I realized recently, because in preparing my manifesto, I dug up his manifesto, and I realized that it wasn't happenstance. It wasn't that he stumbled upon the need to fix the internal governance of the NBA. This was actually one of the first things he said in his manifesto that he was going to do. And he has done it, up to a very, good point. And if by God's grace I'm elected, I would want to build on what he has done to strengthen that financial discipline even more, and reinforce the fact that the NBA is actually a viable financial organization financially, and that it can manage its finances with responsibility. I don't know that there are things that he has done wrongly, but in terms of perception, I would definitely want to try to run, or at least to give the impression that the NBA leadership is more inclusive. And this is not, peculiar to Paul, actually. So in saying this, I'm not focusing on Paul. I'm just focusing on what I would like to achieve if I'm elected president. I think the NBA presidency has been a bit historically, and I don't think Paul has managed to change that significantly, has been a bit too centralized rather than being collective. I would like to run a much more, and I pray that, obviously I don't know who's going to be, if I'm elected, I don't know who I'm going to have to work with, but irrespective of who it is I have to work with, I would like to run a much more, at least an organization or a leadership that is seen to be a lot more collective than Paul has managed to communicate. So it may be, and like I said, I'm not a member of his exco, so it may be that it's just perception that what one is seeing as, everything is done by the NBA president and that the other officers don't really have much of an input. It might be just that, it might just be my perception. But that is the perception, and I would want something that makes sure that everybody is pulling their weight and, carrying their own share of the burden. Because I think that way we would, as a team, be able to deliver even more effectively. What I'll be saying to anybody who is not in support of my ambition is that you should realize that my aspiration to lead the Nigerian Bar Association is not born out of personal ambition. I don't see the presidency of the Nigerian Bar Association as a chieftaincy title or something that I'm entitled to. I see it as a role in which one is called to serve. And the only reason why I'm running for that office is because I'm passionate about our profession, and I'm keen to see the profession regain its pride of place amongst the professions in Nigeria. Other professionals that I talk to, architects, accountants, medical doctors, every other professional used to look up to the legal profession as the one that set the bar for professionalism, for nobility, for dignity. We have allowed that to go away. We've lost it over the years. That is one of the reasons, the primary reason I would say, that I'm running for the office of President of the Nigerian Bar Association, is to restore that dignity of the legal professional. And of course, in the course of this interview, I've tried to address the ways in which I intend to do so. I don't have the monopoly of wisdom. I think that for us to pull our profession back, to return it to its pride of place, we all have to work together. We have to eschew divisions. We have to pull together. We need to bring our strengths together. We need to all pull in the same direction. And if you elect me as president of the Nigerian Bar Association, I promise you that that will be my intention, to bring us all together, to strengthen the profession, and to take it back to its pride of place.